My name is Wade Colton, and before I tell you what happened last spring, I need you to understand one thing about me. I am not a confrontational man. I raise cattle on 81 acres my grandfather bought in 1958, back when this whole valley was farmland and the nearest neighbor was 3 miles off. I keep to myself. I wave at people on the road. I pay my taxes on time, and I have never once, in 46 years of living, been the reason a county commission meeting ran long. That changed the week I found survey stakes in my north pasture. Let me back up. 5 years ago, a developer bought the old Hendricks place next to mine and built a subdivision called Meadow Crest Estates. 40-some houses, vinyl siding, HOA fees, the whole package. I didn't mind. Progress happens, and the Hendricks family needed to sell. What I did mind, eventually, was the HOA president they elected 2 years in, a woman named Denise Farrow. Denise moved into Meadow Crest from somewhere out of state, bought the biggest lot, and within 8 months had appointed herself the moral and aesthetic authority of the entire street. She sent letters about mailbox colors. She measured people's grass. She once left a note on a family's door because their inflatable Halloween pumpkin was, in her words, visible from the cul-de-sac and inconsistent with community standards. None of that was my problem, because I don't live in Meadow Crest. My land borders it on the north side, separated by a barbed wire fence my grandfather strung by hand. My pasture is zoned agricultural. It has been zoned agricultural since before Denise Farrow was born. I run about 40 head of cattle on it, and on quiet mornings you can hear them from the back decks of the nearest houses, which I always figured was one of the nicer sounds a person could wake up to. Denise did not agree. She wrote to me twice about the odor, once about noise pollution from livestock, and once, memorably, to ask whether I'd consider relocating the herd to a more appropriate agricultural zone, for the sake of property values. I wrote back once, politely, explaining that my land was zoned for exactly what I was doing with it, and that it had been used this way since Eisenhower was president. I didn't hear from her again for over a year. In between, I heard about her secondhand, the way you do in a small county where everybody's cousin knows everybody else's mailman. She tried to get the HOA to ban basketball hoops in driveways. She'd send a formal complaint to a family because their above-ground pool was, in her words, not in keeping with the architectural vision of the neighborhood. She'd once called the county sheriff's non-emergency line because a resident's teenage son was mowing his lawn at 8:15 on a Saturday morning, which was, in fact, well within the town's noise ordinance hours. The deputy who took that call apparently spent more time being polite to her than the situation warranted, and I only know about it because his aunt cuts my hair. None of that was illegal. Annoying, sure. Small-minded, in my opinion. But an HOA president badgering her own residents about pool decks and basketball hoops is a different animal entirely from reaching across a legal property line into land she had no authority over. I didn't think much more about Denise Farrow after that second letter went unanswered. I had cattle to worm, fences to mend, and a granddaughter learning to ride her first pony, and Meadow Crest's internal politics were not my business to referee. Then, in March, I found the stakes. They were pink survey flags, 4 of them, driven into the ground about 60 feet inside my fence line, right along the northern edge of my pasture, the part closest to Meadow Crest. I didn't order a survey. I hadn't hired anyone. I stood there in my boots, coffee going cold in my hand, trying to figure out who would have put them there and why. I found out 3 days later, when a certified letter arrived from the county planning office. It was addressed to me, and it referenced a proposed rezoning application for a strip of land along my northern boundary, land that, according to the parcel map attached, was mine. The applicant listed on the paperwork was the Meadow Crest Estates Homeowners Association. The stated purpose was to rezone the strip from agricultural to residential buffer, in order to establish what the application called a vegetative screening easement between the subdivision and what it referred to as incompatible agricultural operations. I read that sentence about 4 times before it made sense to me. Denise Farrow, or the HOA board she ran like a personal fiefdom, had filed an application with the county to change the zoning designation on a piece of my land. My land. Without asking me. Without so much as a phone call. I want to be fair here, because I think fairness matters even when you're the one who got wronged. It's possible Denise genuinely didn't understand property law. It's possible someone on her board told her that HOAs could petition to rezone adjacent land for a buffer strip, and she believed it, and never checked whether that required the actual landowner's consent. What she did not know, and this is the part of the story that still makes me shake my head, was that 6 weeks earlier, I had been sworn in as the newest member of the county's Planning and Zoning Commission, appointed by the county commissioners to fill a vacant seat after old Harlan-Voss retired. And 2 weeks before that letter arrived in my mailbox, at the commission's first meeting of the year, my fellow commissioners had elected me chair. I hadn't told many people. It wasn't a secret, exactly. It just wasn't the kind of thing that comes up over coffee at the feed store. I took the job because I'd spent 15 years on the county's Agricultural Advisory Board and I cared about how this valley grew. I'd watched too many small farms get squeezed out over the years by rezoning decisions made by people who'd never walked the land in question. And when the commissioners asked if I'd fill Harlan's seat, I said yes because I figured somebody who actually worked dirt for a living ought to have a voice in the room. I did not take it expecting to find my own name on a rezoning application filed against my own land. Harlan himself had warned me, half joking, at the retirement dinner the county threw him. "Wade," he said, "the second you sit on that commission, everybody in this county who wants something from a neighbor is going to think you're the guy who can get it for them. Don't let them use you." I'd laughed it off at the time. I didn't think anyone would try to use me by forging my own signature. I called the planning office the same afternoon. I spoke with a woman named Carol who had worked there longer than I'd been alive, and I asked her, as calmly as I could manage, how an application to rezone privately owned land could be filed by a party who was not the landowner. Carol went quiet for a second. Then she said, "Wade, hang on, let me pull the file." She came back a minute later and said something that confirmed what I already suspected. The application included a signature on the landowner consent line. My name, printed and signed, on a form I had never seen, for a meeting I had never attended, granting permission I had never given. I want to be very clear about what I'm telling you, and what I'm not. I'm not telling you Denise Farrow forged my signature herself with her own hand. I don't know that, and I never found out for certain who physically wrote it. What I do know is what the county's investigation later established, which I'll get to. What I knew that afternoon was simpler and colder. Someone had submitted a legal document to a government agency, using my name, to take zoning authority over my own land, and I had found out about it by accident, because a letter happened to arrive before the matter got any further. I did not call Denise. I did not drive over to Meadow Crest and bang on her door, though God knows I wanted to. I have seen what happens to people who let anger drive, and I've buried enough friends' reputations that way to know better. Instead, I did what I do with everything that matters to me. I went and got the paperwork, and I read it, every page, twice. Here is what the file showed. The HOA board, at a meeting in January, had voted to pursue a rezoning of a buffer strip along the northern edge of Meadow Crest. The meeting minutes, which are public record for an HOA of that size in our state, showed Denise proposing the motion and 2 other board members seconding it. The minutes described the land in question only as the adjacent agricultural parcel, without ever naming the owner or noting that consent would be required. Somewhere between that meeting and the application being filed with the county, someone had produced a landowner consent form with my name on it. I recused myself immediately from any commission involvement in the matter. That part was easy, and it was the right thing to do, and frankly it was the only thing that would let me sleep. A chairman does not rule on a case where he is also the alleged victim of the fraud underlying the application. I called the county attorney's office that same week, explained the situation, and asked them to review the file independently of me, with another commissioner sitting in my place for that item. I also, and I'll admit this part felt good in a petty sort of way, requested, through entirely proper channels, copies of every document in the application file, which as chair I was entitled to review just like any commissioner reviewing materials for a docket. I wasn't going to vote on it, but I was allowed to read. What I found, over the following 2 weeks, was a mess that went well past one forged signature. The application included a vegetative screening plan that showed a row of arborvitae trees planted along what the HOA called their buffer easement, trees that, if planted as drawn, would have sat almost entirely on my side of the fence, on land I actively used to graze cattle. It included a cost estimate for the buffer, which the application proposed splitting 50/50ths between the HOA and the adjacent landowner, meaning I would have been billed for a fence line planting project on my own pasture that I never asked for and had, on paper, apparently agreed to fund. It also included, buried on page 14 of an appendix, a letter from Denise Farrow to the HOA board explaining her reasoning. I'm going to paraphrase rather than quote it directly, because I don't have the exact document in front of me anymore, but the substance of it was this. She believed the cattle operation next door was suppressing home values in Meadowcrest. She had researched county zoning code on her own. That phrase stuck with me. with or without the full cooperation of the adjacent owner. She knew. Maybe not that a signature would end up forged. I never got proof she personally did that part, and I want to be careful not to claim more than the record showed. But she knew this required my cooperation, and she pursued it anyway, and somewhere along that road, my name ended up on a form I never signed. The county attorney's office took it from there, and I stayed out of it as much as a person can stay out of something that involves his own land and his own forged signature. An investigator interviewed me, interviewed Denise, interviewed the 2 board members who'd seconded the motion, and pulled the notarization records for the consent form, because in our state a landowner consent form for a rezoning application has to be notarized. That turned out to be the thread that unraveled things. The notary listed on the form was a woman named Patricia Ames, who ran a small notary and shipping business out of a strip mall about 20 minutes from Meadowcrest. When the investigator contacted her, she pulled her notary journal, which by law she has to keep, recording every document she notarizes and who signed it in her presence, and found no entry matching that date, that document, or my name. Nobody named Wade Colton had ever walked into her shop. Her notary stamp had been used on a document she had never actually witnessed. That's forgery, plain and simple, and it's a felony in our state, not a paperwork error. I remember the phone call from the investigator, a soft-spoken man named Greg Aldous who worked out of the county attorney's office and had clearly done this kind of thing more than once. He asked me a string of questions that felt almost insulting in how basic they were. Did I know Patricia Ames? Had I ever been to her shop? Did I recognize the signature on the form as my own? I told him no to all 3, and he said, "That's what I figured, but I have to ask." Then he asked me something that stuck with me more than anything else in the whole process. Had I ever given Denise Farrow, or anyone associated with the HOA, permission of any kind, written or verbal, to pursue any change to my property zoning? I told him the honest answer, which was that the only conversations we'd ever had were her letters about my cattle, and my one polite reply telling her the zoning wasn't going to change. Greg spent the better part of 3 weeks tracing the paper trail. He pulled the property management company's internal email records under a records request, since they held a county contract and were subject to certain disclosure rules for matters involving government filings. He interviewed the 2 board members who'd seconded Denise's motion, both of whom, according to what later came out of the meeting, said they'd assumed the consent paperwork was Denise's responsibility and hadn't looked closely at it themselves before the board voted to authorize the filing. He interviewed the property manager, a company called Ridgeline Community Services, whose regional director initially tried to characterize the whole thing as an administrative oversight until Greg showed him the notary journal discrepancy, at which point the tone of the conversation apparently changed rather quickly. The investigation didn't end up pinning the forgery on Denise personally with the kind of certainty you'd need for a criminal charge against her specifically. What it did establish, and what came out at the county commission meeting where the whole thing was finally addressed publicly, was that the application had been assembled by the HOA's property management company at Denise's direction, using a template consent form that had somehow, nobody involved could ever adequately explain how, arrived with my forged signature already on it, stamped with a notary seal that had been used without the notary's knowledge. The property management company's own internal review later fired the employer responsible, a young man who apparently thought he could speed up the paperwork by borrowing a notary stamp image from an old file and printing it onto the new form, not fully understanding, or not caring, that this was a criminal act. Denise's culpability, in the end, was less about physically forging a signature and more about pushing an application forward for weeks without ever confirming that the cooperation of her neighbor she'd written about so casually had actually been secured, and never once asking why a signature had simply appeared. I share all that not to let her off easy, but because I think the truth of a story matters more than making the villain as villainous as possible. What she did was still serious. She initiated and championed a plan to unilaterally rezone a working farm's pasture, wrote in her own hand that she'd pursue it with or without my cooperation, and then never questioned how that cooperation materialized on paper when it had never actually been given. That's not an innocent mistake. That's someone so certain she was right that she stopped checking whether she was also being honest. The public part of this story happened at the April meeting of the Board of County Commissioners, not the Planning Commission, because a matter this serious, involving potential fraud on a government filing, got escalated above our regular docket. The meeting room was fuller than usual that night. Word travels fast in a county this size, and I suspect half the people in those folding chairs had come because they'd heard some version of the story from a neighbor and wanted to see how it ended, the way people slow down for a car in a ditch. I attended as a private citizen and as the wronged landowner, not as planning chair, and I sat in the third row between my wife Renee and my neighbor Tom Baylor, who runs the ranch on my south side and had shown up, unprompted, in case you need a second pair of eyes on this. Renee held my hand through most of it, which I appreciated more than I let on, because my hands don't usually shake, and that night they did, just a little, right up until the county attorney started talking. The county attorney laid out the findings plainly. The forged consent, the false notarization, the employee at the management company who'd been terminated, and the fact that the underlying rezoning application itself had never had the legally required consent of the actual landowner and was therefore void from the moment it was filed. The chair of the Board of Commissioners, not me, since I'd recused entirely, remember, moved to formally dismiss and void the application, order it struck from county zoning records, and refer the notary fraud to the district attorney's office for further review. Denise Farrow was there. I watched her through most of it, and I want to tell you honestly that I didn't feel triumphant. I felt tired. She sat very still through the county attorney's presentation, and when the commission chair asked if she wanted to make a statement, she stood up, and her voice shook more than I expected. She said she was sorry. She said she believed, genuinely believed, she said, that the buffer easement was good policy, and that she had never intended for anyone's signature to be falsified, and that she hadn't known where the consent form had actually come from until the investigator explained it to her. She said she took full responsibility for pushing the application forward without confirming that consent, because as HOA president that job was hers and hers alone, and she should have called me herself before any of this went to paper. She resigned as HOA president on the spot, right there in the meeting, before anyone asked her to. I won't tell you I forgave her that same night, because that would be a nicer story than the true one. What I will tell you is that about 3 weeks later, she called me. Not a letter this time. A phone call, to my actual number, which she'd apparently gotten from the county clerk's office through entirely proper public channels. She asked if she could come by and see the pasture. Not to inspect it, to actually see it, she said, since in 2 years of writing me letters about my cattle she had never once set foot on my land or asked to. I said yes, mostly out of curiosity about what she'd do with it. She came by on a Saturday morning in May. I walked her along the fence line, showed her where the survey stakes had been, showed her the herd grazing on grass that had fed cattle since before either of our families lived in this county. I don't think it changed her mind about aesthetics or property values or any of that. But she was quiet in a way that felt different from the quiet of someone performing regret for an audience. At the end, she asked if the HOA, under its new president, a retired schoolteacher named Marion who I'd known for years and genuinely liked, could plant a small line of trees entirely on the subdivision's own side of the property line, at their own expense, if I had no objection. Not a buffer easement. Not a rezoning. Just trees, on their land, paid for by them. I told her that sounded fine. The county's investigation into the notary fraud eventually resulted in a settlement between the property management company and the district attorney's office, involving restitution and mandatory compliance training for their staff, though the specifics of that settlement were between them and the county and not something I was ever entitled to full details on. The employee who'd printed that stamp lost his job and, from what I understand, ended up with a diversion agreement that kept the felony off his permanent record in exchange for restitution and community service, which honestly felt like the right outcome for a young guy who made an unforgivably stupid decision but hadn't set out that morning to commit fraud against a stranger. My pasture is still zoned agricultural. It always was. The pink survey stakes came out of the ground the same week the application got voided, pulled by a county surveyor who apologized to me personally for how long they'd been sitting there, since apparently nobody had told him to remove them once the paperwork was filed. I stayed on as planning commission chair. It felt strange for a while, sitting at that table knowing that the whole county had watched, in a roundabout way, what almost happened to my own land. But it also clarified something for me about why the job matters. Zoning isn't just lines on a map. It's the difference between a family losing the use of land they've worked for 3 generations and that family keeping it, and the only thing standing between those two outcomes, most days, is whether somebody in an office actually checks the paperwork instead of assuming it's fine. These days, when new commissioners join the board, I tell them the same thing during orientation, half as a joke and half dead serious. Read every signature line yourself, because sometimes the name on the page isn't the person who wrote it, and sometimes the only reason anyone catches that is dumb luck and a nosy chairman who happened to open his own mail. My cattle are still on that north pasture. Some mornings I stand at the fence and look toward Meadow Crest, and I can just make out a thin row of young trees along their side of the line, still too short to screen much of anything. Marion waves at me sometimes from her deck. I wave back. It's a decent sound, still, cattle in the morning, and as far as I know, nobody's tried to zone it away since.